Okay, ready.
Great. All right. Welcome, Ahalan. Sorry for the delay. Before I begin, I just want to let you all know that this presentation is going to be in both English and Arabic. There is a interpretation option. We have live interpreters who will provide simultaneous translation. There is a little world icon at the bottom of the Zoom that says interpretation. You can select your language there. And I'm going to pass it to my colleague to explain that in Arabic.
Okay, so بالنسبة للمتحدثين باللغة العربية يمكنكم الاستماع للترجمة من خلال النقر على أيقونة شكل الكرة الأرضية في أسفل غرفة أو في أسفل يعني نافذة الزوم. شكرا جزيلا. You have the floor.
All right. So welcome again. My name is Rachel Marandet. I am a researcher at Law for Palestine, and I am a law student and Palestinian solidarity activist in the US. I want to welcome all of our speakers today, our participants, the members of the Law for Palestine Forum, those watching on the live broadcast. Today's event is organized by the Consultants Association in the Law of the Sea, which includes the Consortium for the Study of Maritime Affairs and the Blue Economy, the Ankara National Center for the Sea and Maritime Law, the Interdepartmental Center for Research on the Adriatic and the Mediterranean, and the International Center for Ocean Governance of the Western Sydney University. Today's event is hosted by them in collaboration with us here at Law for Palestine and the Arab Renaissance for Democracy and Development. So today's event is on maritime boundary delineation in the East Mediterranean. It is celebrating the 40th anniversary of the UN Convention of the Law on the Sea, or UNCLOS, 2 days in advance, with experts from both Palestine and Lebanon. The East Mediterranean Sea covers about 1.5 million square kilometers with a total population of 320 million, distributed over 10 countries. As such, it is a very important cultural, socioeconomic, and ecological hub that is important to look closely at. Today is the first session in a two-part series. Today, we will be focusing on the borders of Palestine and Israel, and the next session, which will be held on Monday, December 19th at this same time, will focus on the boundaries of Lebanon and Israel. UNCLOS codifies and develops the law of the sea with a focus on principles of peace, security, cooperation, and friendly relations among all nations in an effort to establish a legal order for the seas and oceans. A powerful and ambitious goal that to date has been formally endorsed by 168 countries, including Lebanon and Palestine, and has been accepted to different extents by non-ratifying countries as reflecting customary international law. One of the major achievements of the convention is the adoption of rules and procedures for the delimitation of maritime boundaries between states with adjacent or opposite coasts. Despite the significant contribution of UNCLOS and the progress made by the Mediterranean Rim states to negotiate an equitable solution for the delineation of their maritime borders, the Eastern Mediterranean Sea region remains a hotspot of unsettled, overlapping.
Sorry, Rachel, can you slow down a little bit for the interpreters?
My apologies.
No worries.
So two important examples of unsettled maritime boundary disputes in the Eastern Mediterranean Sea region are the ones between Palestine and Israel and Lebanon and Israel. Today's discussion between international lawyers, experts, and NGOs directly involved and who have firsthand experience with the issue at stake aims to examine and discuss the different positions of Palestine and Israel on maritime boundary delineation, with the objective of identifying a range of possible solutions to facilitate the negotiation of an equitable solution for all parties consistent with international law, which would allow to further maritime peace and security in the region. With that said, I am honored to introduce our first speaker, Professor Mutaz Qafisheh, who is a professor of international law, the founding and former dean of Hebron University College of Law and Political Science in Palestine, and the chair of Law for Palestine's Board of Trustees. He holds a PhD in international law from the Graduate Institute of International and Development Studies in Geneva and is a practicing international lawyer. He formerly worked as a human rights officer at the United Nations Office of the High Commissioner for Human Rights in Geneva, Beirut, and Ramallah. He authored and edited 6 books and some 50 peer-reviewed articles published by international publishers and journals. One of his recent articles, conducted during a fellowship in Berlin, tackles the issue of Palestine and the law of the sea. Professor Qafisheh will talk about Palestine maritime boundary delimitation in accordance with the UN Convention on the Law of the Sea. Professor, you have the floor for about 12 to 15 minutes.
Thank you, Rachel, and good evening to everybody, or good afternoon for those who are in the United States, and buongiorno for our Italian partners. First of all, let me thank all the organizers of this event, especially my colleagues in the law for Palestine, Hassan Adel and Hassan bin Imran and other colleagues. Our partners in the ARDD and our partners in ASCOMARE Association, our Italian partner. And also, I would like to thank you, Rachel, for this moderation. And let me also thank my co-presenters, who are, just to mention, are my students actually in a course called International Organizations, which is part of the master's program in international diplomacy at the Hebron University Political Science Department, which is part of the law school. My presentation tonight relates, as Rachel mentioned, to the Palestine international maritime boundaries offshore Gaza Strip. Just a little bit background: the historical Palestine, which includes now Israel and the West Bank and Gaza Strip, extends. It has a coastline that extends to 13 kilometers. What is remaining for what we call now Palestine, which is the West Bank and Gaza Strip, only 40 kilometers extending offshore Gaza, which amounts to approximately, or a little bit less than 13% of the entire coast of Palestine, which means that Israel gives us only, or left to us only 13% of the coast. And yet, this coast, the Gaza coast, has been under blockade for the past 50 years under Israeli occupation. And actually, it was even under blockade before that since 1948, which means that preventing and denying the Palestinians the possibility to get benefits from the sea, from all fronts, from fisheries up to trade, up to, of course, sovereign rights. Just to, I'm just trying to present. Okay. So here is the East Mediterranean region. There are different countries overlooking this region, and there are so many overlapping claims over the Mediterranean Sea. And most countries overlooking the Mediterranean are parties to the United Nations Convention on the Law of the Sea, with the exception of Israel and Turkey. And the rest of the countries are party to the UN Convention, which provides, as Rachel mentioned, comprehensive options for adjacent neighboring states and opposite states, various ways to settle their boundaries and to solve their conflicts. Here is just a photo of Gaza. Gaza, as we know, is a very crowded region, which is very also tiny over the Mediterranean Sea. Its size only 336 kilometers, which has also over 2 million people living under complete blockade from all sides, from the land, sea, and the sky, or the air. Oslo, as the Palestinians reached the Oslo Agreement with Israel, and this is the photo that indicates the Oslo Agreement. Oslo actually provided several restrictions on the use of the sea by the Palestinians, and gave only up to 20 kilometers for the or up to 20 nautical miles for the Palestinians mainly for fishing, which is called the fishing area. But as we know, the Oslo Agreement, which was signed in 1993 and 1995, provided several restrictions on the Palestinians. For example, provided this area called Area K on the north of the Gaza Strip, and Area M in the south, at the borders of Gaza. The northern part is like 2.5 kilometers, which is a buffer zone that Palestinians can't enter in any way. The fisheries, although it was provided up to 20 nautical miles, in fact, in practice, Israel only allows the Palestinians to, since the Oslo until now, only to use up to 6 nautical miles, which is about 9 to 10 kilometers. And in effect, especially since 2009, and started from 2006, Israel only allows the Palestinian fisheries to use only 3 nautical miles, which is about 6 kilometers or even less. So this is what Oslo gave the Palestinians, which is, as we know, contradict international law and international humanitarian law, because it denies the Palestinians their right to self-determination over their national resources. And this is the chart of Oslo, and this is what the UN clause gives the Palestinians. With the accession of Palestine to the UN Convention on the Law of the Sea, Palestine gained sovereignty over its territorial sea, which extends up to 12 nautical miles. And what is even more important is its sovereign rights over the exclusive economic zone, which extends up to 200 nautical miles, which is in kilometers, about 360 kilometers. On the top of the sea, which is the exclusive economic zone, as well as the continental shelf underwater. And this is the chart that explains the various Palestinian areas. This is the first area, which is the territorial waters, the contentious zone, and the economic, the exclusive economic zone. And this was part of a declaration that the Palestinian Ministry of Affairs, through using an international company called International Mapping, based in Maryland in the United States, and it drew this area based on the UN clause or the UN Convention on the Law of the Sea, which gives any coastal state to launch or start delimiting or specifying its maritime zones unilaterally. Of course, this would not be binding to other states unless after having bilateral agreements. So Palestine needs to have a bilateral treaty with Israel, bilateral treaty with Egypt, and bilateral treaty with Cyprus. But still, this chart or this unilateral declaration by Palestine, as well as any other state or as the case of any state in the world, give the coastal state several rights. So why this declaration is important and why this chart is important? Because it's, first of all, preserves the coastal state, in this case Palestine, preserves its rights, meaning that other states could not use this area or these areas without the consent of Palestine. Not only states, but also companies and ships and fisheries and oil companies, gas companies. And as we know, there are trillions of reserves, gas reserves have been discovered in the Mediterranean or East Mediterranean region, including so-called Gaza Marine Field, which contains up to 1 trillion cubic feet or even meters. And this is just the initial discovery. And I think there will be much more than that, especially in the exclusive economic zone. And also why it's important, because also it create responsibilities on other states, oil companies, not to use these areas under the possibility for Palestine to to go to international courts, as one of my colleagues will present. Palestine could, for example, go to the International Tribunal for the Law of the Sea, could go to the ICJ or the International Court of Justice, as well as to arbitration. So this declaration, which was sent or communicated with the UN United Nations Secretariat in 2019, is very significant. Israel has reacted to that declaration and was very aggressive in its reaction on the 14th of January 2020, which basically did not recognize this area and said that Palestine has no right whatsoever to declare over its so-called maritime zones on two pretexts. Actually, the first relates to from the Israeli perspective that Palestine is not a state, and then and only states can declare maritime zones, and which is and this is of course not correct, and it's as I called it, manifestly ill-founded under international law, because Palestine is recognized as a state by other state parties to the UN Convention on the Law of the Sea, as well as in many international organizations and treaties, and why Palestine would not have the right as other state parties to this convention. As well as Egypt. Egypt also objected certain geographical coordinates that Palestine specified in this chart. But in principle, Egypt agreed with Palestine-based line, with the Palestinian territorial say, and almost, and I'm here just generalizing, almost 50% of the maps that has been drawn by Palestine. So these are the different Eastern Mediterranean Sea boundary claims, and here we show the Palestinian Sea, which is very, very significant. Although the Gaza Strip, as I mentioned, is very, very tiny strip of land, which consists only 2% of the historical Palestine, but the maritime zone extends the size of the Gaza Strip in the territorial waters up to 250% more than the size of Gaza Strip, and the exclusive economic zone could be extended up to 14,800 square kilometers, which is almost 3 times bigger than the entire territory of the West Bank and the Gaza Strip combined, which consists together the state of Palestine. So again, although Gaza Strip is very small, the sea, the various maritime zones are significant, and of course this area creates various obligations on other states, the state of Israel and Gaza, as well as Cyprus. Just to mention very quickly that both Israel and Cyprus have a maritime convention or treaty that was signed in 2010, although Israel is not party to the convention, but yet it reached an agreement with Cyprus based on the UN clause. And also Egypt reached another convention or treaty with Cyprus in 2003. These two conventions are very important to look at, because Palestine can challenge the Israeli intervention in its maritime zones, and probably in a way force or put some pressure on Israel to negotiate with Palestine or conciliate or reach an agreement, or even to sue Israel by filing a lawsuit against Cyprus, challenging its convention or treaty with Israel, because the agreement that Cyprus signed with Israel affects the maritime zones of Palestine. And again, Palestine also can challenge certain border areas with Egypt by filing a case against Cyprus in this case, because Egypt, as one of our colleagues will explain, Egypt declared in 2017 that it does not recognize any adjudication process or any judicial process relating to its maritime zones, denying the Palestine the possibility of going to any court, either the ICJ, the International Court of Justice, or the International Tribunal of the Law of the Sea, or even arbitration, leaving the dispute for to be resolved only through negotiations or so-called compulsory conciliation. That was in 2017 after the Palestine accession to the UN clause, and after President Abbas declaration in 2015, shortly after the Palestine accession to the UN clause, President Abbas also declared the various Palestinian maritime zones, which were crystallized and become more detailed in 2019 when the Ministry of Foreign Affairs filed its communique with the United Nations Secretariat. Just to conclude, the issue of maritime zones and the law of the sea relates to many areas of international law, not only the law of the sea, but also relates to international humanitarian law, because Israel still is the occupying power of Palestine, and there is now an emerging field of international humanitarian law called maritime occupation, and Israel has obligations under the international humanitarian law, the ITL, which basically relates to the Oslo agreement and its stipulation that it denies the Palestinians the right to get access to the sea. It also relates to international human rights law, because the Palestinians, as any people in the world, have the right to self-determination over their national resources, and also have the right to fisheries, which also relates to the right to food. It also has some relevance to international criminal law, and here is the photo of the International Criminal Court, the ICC, because pillaging or stealing the national resources or natural resources of the people could be or could amount to a crime of pillage, which is part of the Rome Statute of the International Criminal Court. So that would be considered like taking the Palestinian gas or petrol or fisheries, or denying the Palestinian the right to access to these areas can amount, and that of course requires further research. It also relates to international responsibility, because when Israel denies the Palestinians their right to use their maritime zones, that opens the floor for discussion and research to discuss the international responsibility, the question of compensation, repatriation, restitution, etc. But not only on Israel, but also on other states that might use or abuse Palestinian maritime zone. It even has some relevance to the law of aviation, especially if Palestine has sovereignty over its territorial water, then it will have sovereignty over its airspace above that area, and that creates obligations on aviation companies and planes from various countries in the world adhere to international law in this field. And finally, it has also relevance to the law, so-called maritime law, which is another field of law, which is a neighboring field next to the law of the sea, and particularly the possibility for Palestine to access or to get membership or to become member of the International Maritime Organization, which is a topic of another colleague. If I exhausted my time, I think I took already 20 minutes or even more. So I thank you, and I look forward to the questions and discussion.
Thank you very much, Professor Qafisheh, for those insightful comments. I will now give the floor to our next speaker, Hanifeh Badr, who is a researcher on the International Tribunal for the Law of the Sea, to present her research paper entitled Palestine Before the International Tribunal for the Law of the Sea. Ms. Badr, you have the floor for about 5 minutes. You are muted.
صوتك مكتوم. Thank you very much. Hello, everyone. I will try to be brief as much as possible. I will start talking about the part 15 of the Convention on the Law of the Sea, about the settlement of disputes. There are two parts about the settlement of disputes. The first one is optional, and it's in accordance with Article 33 of the Charter of the UN. Based on the convention, this includes negotiation, mediation. And the second part is about the adjudication. The convention gives 4 options for the parties to choose among. The first option is the International Tribunal for the Law of the Sea. The second option is the International Court of Justice. The third option is the other court. And the fourth option is an arbitration. As for the International Tribunal for the Law of the Sea, it's considered an achievement that is added by the UN clause, because all parties will be interested by this tribunal. This tribunal represents all countries of the world compared to the International Court of Justice. The International Court of Justice is limited to countries, but the International Tribunal for the Law of the Sea can adjudicate other parties, including other parties that are not states. I would like also to talk about the constitution of the tribunal and the history of the tribunal, but I don't have time, so I will get into the Palestine topic. Palestine joined the UN clause in 2015, but Palestine issued announcement about the specialization of the tribunal for the settlement of disputes. So the option is arbitration for Palestine. I would like to refer that the 4 options that are given in the convention for states, if the state doesn't opt for one of them, the arbitration is the chosen option. As for the UN clause, this is mandatory. Palestine is, the option of Palestine is arbitration. As Dr. Mutaz explained, there are 3 countries dealing with this: Cyprus, Palestine, and Egypt. Israel is not part of the UN clause, and it didn't give its consent. So Palestine has no way to obligate Israel. Still, we have Egypt and Cyprus. Cyprus has not given its consent for jurisdiction, but they released consent for the International Court of Justice. And Palestine also accepted the jurisdiction of the International Court of Justice, so they can adjudicate Cyprus through this. A third option is an agreement, a special agreement, to go to the International Tribunal for the Law of the Sea. So Palestine, if they declares their consent, they can go to the International Court of Justice or the International Tribunal for the Law of the Sea or the arbitration. As for Egypt, Egypt chose arbitration when they made their choice. They declared their consent that they want to go through arbitration, but in 2017, they declared that based on an article stating that a state can refuse all the 4 options, Egypt, Article 298, that Egypt used to issue this declaration, they are saying that the state that would go to this option are obligated to go through reconciliation. When a country signs an agreement, they should find a solution for the dispute. We have an example from another point of the world, which is China. China in 2016 declared an announcement like the one issued by Egypt in 2017, refusing the procedures that are listed in the UN clause. But in 2013, China has had a dispute with the Philippines. In 2013, the Philippines adjudicated China through arbitration. and the court was accepted and was formulated in The Hague, and a judgment was issued. China did not accept the judgment, but China did not recognize the judgment. My idea here is that when a state gives such a declaration, this doesn't mean that they cannot go to arbitration. So even if Egypt has declared that they don't accept the fourth options, still we can go through arbitration or through one of the options, and we can go through the International Tribunal for the Law of the Sea. Still, Egypt mostly, if they don't, if Palestine has no agreement with Cyprus through the about the borders they declared in 2019, which is the maximum limits of the UN clause, and it's overlapping between Israel and Cyprus and their borders. If Egypt reaches an agreement with Cyprus, the borders that they will reach will be less than the borders that they can get through the UN clause, but at least they will be recognized. The question remains, if Palestine has the political will to go through adjudicating Egypt or Cyprus. There are no indications of such a thing, and thank you very much.
Thank you very much, Ms. Bader. I will now give the floor to Mohammed Abu Omar, who is a researcher on the International Seabed Authority, to present his paper on Palestine membership in the International Seabed Authority. Mr. Abu Omar, you have the floor for about 5 minutes as well.
السلام عليكم مساء الخير للجميع.
Hello everyone, good evening everyone. I will talk about the International Seabed Authority that was established according to the UN clause in 1982. And it gives the right to exploit resources or extract minerals in the seabed. It was established in the 90s after the issuance of the UN clause. The seabed is considered as the region outside the national authority, and it's part of the oceans and seas that are not governed by any domestic rules. So it's outside all the other regions. It's 54% of oceans and seas. These regions have great minerals and resources, and such regions are established on several principles established by the UN clause. The main point is that all resources in such regions are common heritage that cannot be exploited but for peaceful aims, so they cannot be extracted for military purposes like in the 70s and 80s, and they should not be exploited to manufacture arms. Such regions also are considered under the jurisdiction of the international community, so no company or a state can exploit except by the consent of the International Seabed Authority, that is a representative for these regions and the rights to exploit the resources of these regions. Any exploitation without the consent of this authority is not recognized. With this, we cannot talk about any sovereignty over these regions by states. There is no individual sovereignty over such a region because it's considered common. All resources are considered as common heritage for all humankind. The headquarters of this authority is where they signed this convention in 1982. This authority consists of 3 devices and 2 branches. The first device is the General Assembly of the authority that has all members. 198, and all signatories are considered in the UN clause are considered members in this authority. It's considered as a legitimate authority, and it's held on an annual basis. It makes decisions based on procedural or other decisions by votes. They mainly vote. They mainly choose the members and codify the rules of the regions, and talking about also other economic benefits. So it's the authority specialized in distributing the financial resources that is derived from the exploitation. The other part of the authority, Palestine was a member in 2015 based on the signing the convention of this authority. By signing this convention by Palestine we confirm our rights as Palestinians, even if Israel is part of this convention. Palestine is allowed not to pay the fees in this convention as they don't produce any minerals, so they don't have any financial obligations towards this international seabed authority. And it's confirming their rights even if Israel is not part of this. This is it. Thank you very much.
Thank you very much, Mr. Abu Omar. I will now give the floor to Samah Blasi, who is a researcher on international maritime organizations, to present her research paper entitled Palestine Membership in the International Maritime Organizations. Ms. Blasi, you also have the floor for about 5 minutes.
Good evening to everyone. Welcome everyone. Today I will talk about the International Maritime Organization. It's the international authority that controls and regulates and supervises the implementation of the law. First, I will talk about the difference between the maritime law and the law for the sea. Maritime law is about shipping, while the law for the sea is about the behavior of states within their territorial and other coastal zones. So the maritime law is about the activities within the law and about the companies shipping through the sea and all the transactions, as 70% of the earth is nautical. So this maritime law is there to protect and organize and regulate the economic transactions. And there was a need to control and supervise these transactions by this law. The first convention gets back to the first convention that was signed by few states then as a reaction to the Titanic disaster. Because of the commercial navigation through line, there was a need to have such an authority to protect commercial transactions through the international trade. As vessels transport and spends most of their time at the sea, and they transport among and through several countries. So this is why an international effort to maintain the safety of such transportations is better than individual initiatives. And after, according to an agreement in 1948 in a conference held in the United Nations in Geneva, this was the first authority or international body specialized in maritime transactions. Although it was established in 1948, it got into force in 1945, and it had the name a consultancy, and then it changed its name to International Maritime Organization. Its quarters in London, the capital of the UK. The strategic vision of the organization is to maintain the safe shipping through cooperation. In their vision, they promise to protect and ensure development, maintaining development until 1930. As for financing, it's financed by members and also other commercial activities like holding conferences. The organization consists of a general assembly and an executive body and 5 other bodies. As for the assembly, it's a representative of all members, and they hold meetings every 2 years. As for the committees, there are 5 committees: the Maritime Safety Committee, the Marine Environment Protection Committee, the Legal Committee, the Technical Cooperation Committee, and the Facilitation Committee. As for the executive body, they cooperate between all the other bodies. Members or the staff are almost 300 officers. We have 2 categories, 10 countries, and B at other 10 countries, and category C with 10 countries that are not they didn't win the elections. According to Article 2 of the treaty that established the organization, it states that the functions of the organization are like consultancy. We can notice here that the organization does not impose policies. It was established to regulate policies, but not to impose them. When states accept the policies, these policies become as domestic laws that should be implemented by states. Still, the organization develops a program to review all the policies, maritime policies in 2016, but there are no counter procedures if countries don't implement the policies adopted by the International Maritime Organization. They give only, the organization gives only recommendations about the performance of the state. The slogan of the country captures the aims of this organization, aiming for the safety and solving all the legal disputes and facilitating the transportation. The purposes of the organization is to regulate and put the regulation and also prevent the pollution in the seas. Most agreements under the organization are either to save souls, fight pollution or prevent the pollution by vessels, and train, prepare, and facilitate commercial activities. As for the members, we have 175 members in addition to other 3 parties. 66 governmental bodies and 55 non-governmental bodies supervise the activities with 5 regional offices. As for membership is allowed to all states according to Article 7. The conditions briefly is to have the country coastal borders. So any state that wants to be a member, if they are a member in the UN, they should transfer their document to the secretary, and they should call the general secretary before they put the document to be provided by the fees that they should pay based on their loads. Now I will talk about Israel joining this organization and the reservations of Arab countries towards Israel joining the organization. Israel joined on 24 April 1959, and Iraq joined in 73, and they reserved that Iraq joining the organization, this doesn't mean recognizing Israel or having relationship with Israel. The Bahrain had a similar reservation, and the UAE and also another Arab country had similar reservations. Bahrain government in July 2021 withdrew their reservation, and they have normalization with Israel after the New Deal of the century. As for Israel, they perceived such reservations such as political reservations with no legal understanding. So they refused these totally and said that such announcements are not representing at all any legal procedure, and they are not impacting the obligations of the members of the organization. And they decided to treat such reserving countries in the same way. Countries that were included in such response by Israel: Bahrain, UAE, Yemen, and Iraq. As for the gains of Israel for joining this organization, Israel was able to supervise transporting through Madiq Hermes, and they were able to act Israel as a country in the region, an important actor and a part of this ally and part of this organization that protects the safety of the region. This helped Israel feeling that they are not isolated and they are part and actor in the region. They also consolidated their role as a supervising country in the region, especially over Iran. As for Palestine and the International Maritime Organization, Palestine as a state is able to join the International Maritime Organization. According to Article 7 of the organization, all states can join, so Palestine can join. As for the conditions to join, it applies on Palestine as they have coastal borders, and 2/3 of the members should vote for the acceptance of the a new member, and this is something that Palestine can achieve if they lobby for this. And Palestine can also do all the obligations, meet all the obligations under this organization, but still Palestine did not join this organization because the Palestinian leadership does want to focus on the inhumane crimes committed by Israel, and they want to get an advisory opinion about the legitimacy of the acts of Israel. So they cared to go to the authority to delimit their borders, and they had also other priority to head towards international organization that tackles the legitimacy of the occupation. Palestinian leadership has also a political will to join the International Maritime Organization, but they postpone this to another phase after joining because they have other priorities that is more urgent. If Palestine joins the International Maritime Organization and obtain the membership, what gains they should get? There's a diplomatic importance for this and a legal importance and a commercial, because through this, they will help the economy in Palestine and will enjoy the help of the organization. They will also be able to improve transportation through maritime and be able to register their vessels and able to increase the work in the exclusive economic zone. They can also purchase ships and vessels even if they don't have a port. And this way they can reduce the blockade of Israel and allow foreign vessels to enter Palestine for commercial reasons, and allow Palestinian vessels to go away and increase the commercial transactions between Palestine and other countries. By this, we give more work opportunities to Palestinians. We can also improve the economy and negotiate again Oslo Accords, knowing that Palestinian leadership can liberate from Paris Agreement whenever they want. And this is not linked to joining the organization, but the PLO has no other alternative.
Excuse me, sorry to interrupt, but we are just running short on time. So Ms. Blasi, if you could just wrap it up, that would be great. Thank you. You're welcome to conclude your comments if you want.
Fine, okay. I'm almost there. This helped building new foundations, and Palestine will be able to attend conferences and enjoy the help and the financial help of the organization. This will also increase their presence in the international arena and will show the economic burdens of the occupation. They can also have diplomatic relations with other states, and this will encourage more states to recognize Palestine bilaterally and improve and encourage the right of determination of Palestinians. Palestine will be able to participate in making decisions within the organization and join other agreements and treaties under the umbrella of the organization and enjoy all the financial help to third world countries. Palestine, as a member, will force other countries to treat Palestine as a country, and this will be an implied recognition of Palestine, and this will change the position even of the UK recognizing Palestine even impliedly. Refusing any suggestion to establish a port in Gaza by Israel is a big challenge. There is diplomatic efforts to pressure Israel to delimit again the borders, the maritime borders. There's no efforts to get an advisory opinion from the UN to describe the occupation, even if it's an occupation country, and this will be a pressure. By this I end. Thank you very much.
Thank you very much. We are now going to move into our question and answer session. Participants are welcome to ask questions either via the chat in English and I can read them out, or you may raise your hand and I will give you the floor to ask a question or make a comment in either English or Arabic. If you make a comment, please limit it to just about 1 or 2 minutes. And if you ask a question, please indicate if it is for a specific speaker or any of the speakers. After each question, the panelists will have a couple of minutes to answer or comment on the questions. And so with that, Sabah Shaheen, go ahead. Right, which of the speakers would like to take this?
Mutaz, you are mute. We can't hear you.
I can hear you. I don't know if.
Okay. Maybe because he speaks in Arabic, because I am in the English channel. No worries.
I think you're good. Go ahead. Thank you.
And these borders have been recognized as part of international borders of Palestine, and also the northern borders of Palestine with Israel also have been determined. Then the rest, the various zones, the Palestinian Territorial Sea and the exclusive economic zones, starts from the baseline that would be fixed from the beach or the coast of Gaza. So if the land is fixed, then the various maritime zones would be eliminated under the UN clause or the UN Convention on the Law of the Sea. And I think the borders of Palestine are or could be eliminated either unilaterally by Palestine under Article 5 and Article 15 and 16 of the UN Convention on the Law of the Sea. And if other states don't recognize this, they are welcome to come to Palestine and conclude bilateral treaties with Palestine.
All right, I will take the next question from Mr. Lucci, I believe, or Miss Lucci.
Yes, thank you very much, Raquel. Thanks first and foremost to all the speakers and also our colleagues from Law for Palestine and ARDD for hosting these events. I'm Pierandrea from ASCOMARE, and I would like to make perhaps a comment and a general question to all the speakers. I think this was a very interesting and fruitful discussion so far, and there was something I believe very important that was mentioned by Professor Mutaz about, especially now that, for instance, that underline the concept of the land dominates the sea principles. That is the element of the entitlement, I think, which in this specific case makes the situations, the dispute with Israel particularly complex, because as Professor Mutaz mentioned that one of the arguments that was raised by Israel in its reply to the 2019 declaration was indeed the aspect of the statehood, which in a way is connected also with the other topics that were touched upon today, for instance, for the memberships. And I think there is something, and this is the comment, sometimes it is a little bit overlooked from the general discussion, but it's very interesting what the decision of the International Court of Justice will be in the pending case of 2018. Palestine versus the USA, because in that case, indeed, it would be necessary to take a specific decisions according to Article 34 of the ICJ statute on the statehood, indeed, and the possibility to consider this, to settle this issue once and for all, against also the backdrop, as Professor Mutaz mentioned, of the amicus curiae observations made by the ICJ to the ICC case. So that would be a very interesting also discussion. When it comes to the question, I very much agree that let's say when with regard to the possible delimitations of the possibility to apply or to institute proceedings against the neighboring countries is particularly complex. Some of them are non-contracting parties to the conventions, as was indicated. Others are, in any case, have accepted, like Egypt, to the compulsory settlement of disputes. But there is something that I think it's very important that for some reason in the Mediterranean Sea is not used very much, which is paragraph 3 of Article 74 and 83 of the UN Convention on the Law of the Sea, which is a mechanism allowing, to a certain extent, requiring also states parties to the convention to make every effort to enter into provisional arrangements to manage certain areas. Now, this is an instrument that worked very well, for instance, in the Caribbean area, also in part of the Indian Oceans. We have a dispute that was very complicated between Mauritius and Seychelles that before the conclusion of a treaty for the Mascarene Plateau and the water column that was particularly successful. These provisional arrangements allow to, for instance, to apply mutual constraint or restraint, but also to co-manage certain areas. And I think that this could be something very interesting to explore, especially when it comes to Egypt, for instance, which in any case is, correct me if I'm wrong, but in any case, they recognize the state of Palestine since the 80s. It's a contracting parties to the convention. So it's this could be a possible way forward because as Raquel also mentioned at the beginning, it's important to try to look at the possible range of solutions, also considering the state of the art. So my question in particular to the speakers is, do you think that this could be a solution? So probably working on a provisional solution, on a provisional arrangements with the neighboring countries, at least for preserving the state of play with us. Thank you very much.
Yeah, thank you, Mr. Lucci or Brandri. I pronounced your name correctly. Yeah, I think the question of provisional measures are not really raised between the Palestine and would not be even overseen to be raised because Israel does not recognize any form of sovereignty of Palestine or control or sovereignty or even fishing over the territorial sea. Although Israel is claiming that it withdrew from Gaza in 2007, but in fact it's still controlling the sea, denying any ship to enter the Palestinian coast, even controlling the Palestinians swimming in the Gaza. So Israel is not really ready to go to that far. As regards to Egypt, I think now Palestine is trying, as I think Hanifeh mentioned, is trying to solve any conflict or disagreement, I would say, with Egypt, mainly by negotiations, and they are doing it in like a Mediterranean way or even an Arab way, like making conciliation, consultation, negotiations, and most of these negotiations and consultations are really done in a discrete way. But there is a prevalent or clear development in this regard is the formation of the East Mediterranean gas forum. It was recently or has been recently established, and it seems to me that it is a reaction from certain countries in the region to look at the economic side of the issue rather than looking or solving the border or boundary issues, because it seems to them or it seems to me that they think that it is almost impossible for the countries to agree. Look at the question of, for example, dispute between Cyprus and Turkey and Greece. I think it's even more complicated than the issue of Palestine. So they try to use the East Mediterranean gas forum as a way to go around the issue of delimitation or in order to get benefits from the gas issue. And the war of Russia and Ukraine accelerated the process, because the European countries they desperately need the gas from East Mediterranean, because it's very close to Europe. So as also we know, in June 2022, the European Union reached an agreement with Israel and with Egypt in order to explore to export gas from Israel through Egypt to the European Union. Of course, the Palestinians, they disagreed with that agreement because they felt that this agreement would, in a way, although it did not declare that it violates certain sovereign rights for Palestine in its maritime zones. But still, even the East Mediterranean region, it ignored significant countries in the region, Turkey, Syria, for example, and at the same time, they included other states like Italy and France and even Jordan, which is not even a coastal state in the East Mediterranean. So for me, it's like an economic, political arrangement rather than having the possibility of determining or reaching an agreement that relates to border delimitation issues, including the issue of provisional measures. I think it's also not in I think it's a very good proposal, but I think the states are not ready yet for that. But still, it could be an opportunity. The East Mediterranean Gas Forum could be viewed as an opportunity in order at least to try to move things a little bit further. It's an attempt to create a forum for negotiations, meeting, discussions among states that might pave the way in the future for discussion on a higher level, which could be border delimitation issues.
Thank you, Professor. All right, so for the sake of time, I will take the next two questions of people who have their hands raised together, and then the commentators can answer, and I will then read the questions we have in the chat together, and our presenters can comment on any of those. First, Ms. Longo, you can ask your question, but could people asking questions please keep their questions to under a minute? Thank you.
Yeah, hello. Mesal Khair to our Palestinian friends, and good evening, everyone. My name is Andrea Longo. I'm a PhD candidate at the University of Milano Bicocca in Italy, where I work on human rights in the fisheries sector. I'm very much interested in the issues that have been discussed so far. So thank you very much to all presenters. My questions is very quick and short to Professor Qafisheh. And it's the following: what is the validity of the Oslo Agreement today, after almost 30 years from the dates of the declaration agreements? And because to my understanding, the situation has changed a lot, both politically and legally, of course. So clearly, I think there is the understanding that the validity today of these agreements is important and relevant to defining the delimitation issues, but not only those, obviously. Then I would have another question, but perhaps this concerns fisheries, but perhaps I can send you an email if you're okay with that.
Sure.
All right, and I will also take the question from Mr. Rajabi, and then pass it to the speakers to answer both together.
أحمد رجب تفضل. Unmute yourself. أمل افتح الميوت. muted. افتح المايكرو مايك. أحمد.
Well, I believe.
I study in law, Ahmad Rajabi. Now, can Palestine sign the treaty of delimitation with Turkey, although Egypt and Israel are against this?
Regarding the validity of the Oslo agreement in general, I think my position is that Oslo agreement has been signed to last for 5 years, and that has been lapsed. There are some like a discussion that has been extended de facto or implicitly, or even there are some unconfirmed news that there was like an extension of the Oslo agreement. But I think you are right. You know, if we look at the Vienna Convention on the Law of Treaties modalities regarding the end of treaties, I think there are several grounds for the Oslo agreement, especially when it comes to the maritime arrangement under the Oslo. I would say there are several reasons or factors that would say that that would let us conclude that Oslo is no longer binding to the Palestinians. The change of circumstances, as you mentioned, is one of them. Things significantly changed, especially after the Israeli withdrawal from Gaza, and Israel claimed that Israel does not is no longer occupying Gaza. So if it is not occupying Gaza, why it's occupying its sea and its maritime zones? Why and why it's denying the Palestinians from fishing and from exploring and exploiting their natural resources in that area? So and also the issue of gas exploration and natural resources has not been discussed in Oslo. So that gives the room for the Palestinians to claim and proclaim their rights in the Mediterranean with and without, and specifically without Oslo. And it's also very important to mention that Oslo, when it comes to human rights, which relates to your research, contradicts the fundamental rights of the Palestinians. And as we know, under the Vienna Convention on the Law of Treaties and also the Fourth Geneva Convention, if a special treaty contradicts the U.S. Cogen's rules of international law, and in this case the human rights of the Palestinians over their natural resources, especially gas resources, the right to self-determination, sovereignty of the Palestinian people in land and the sea, and also the Fourth Geneva Convention that I think Article 47 clearly specifies that if a special treaty between the occupier, in this case Israel, and the occupied people, like takes the rights of the occupied people or undermines the Geneva Convention or the rights, the fundamental rights of the convention, this particular treaty or Oslo, in this case the Oslo Accords, would not be valid or would be null and void. So basically, what is Oslo now is mainly like it's a security arrangement, and it is a de facto arrangement between the Palestinian Authority and Israel, and it's not respected. And particularly when it comes to the law of the sea, Israel did not respect any part of the Oslo Agreement. For example, there was a provision in the Oslo Agreement regarding the establishment of a port and harbor of Gaza, and Israel delayed and postponed all the possibilities for the parties to reach an agreement regarding the Gaza port and harbor, and the possibility of other ships international and foreign ships to enter into Gaza, and rather it turned or directed or redirected more ships to go to Israeli ports instead of coming to Gaza. The question of the fishery zone, according to Oslo agreements, it could extend up to 20 miles, and in practice, Israel gives the Palestinians only 3 miles of offshore Gaza. So substantially, if there are like at least 3 factors under the Vienna Convention and all of the treaties. One of them, the lapse of the time, or the end of the time, change of circumstances, and the fundamental breach that Israel conducted with regard to its obligations toward the Palestinians with regard to the law of the sea, and of course to other parts of the Oslo Agreement, including the law of the sea. So the Palestinians, I think they have, just to conclude on this, Palestinians have no obligation whatsoever under the Oslo Agreement when it comes to the law of the sea. The question of Ahmad regarding the possibility for the Palestinians to reach agreement with Turkey regarding the possibility of exploring gas or oil resources offshore Gaza is a question. I think it is a sovereign question, and I think it's a very good question, Ahmad. It's a sovereign question that if Palestine and it's if the position that Palestine is party to the UN Convention on the Law of the Sea and has rights and sovereign rights over its territory and over its exclusive economic zone, then it has the right to conclude any treaty with any country in the world. It could be Turkey, it could be even Iran, it could be Russia in the future, in order to explore and exploit and search for oil and gas in the Palestinian maritime zones. There were some news on this. There were some rumors and discussions several years ago on the leaked information that Palestine is in the process of negotiating with Turkey in this respect, that it has been delayed. But I think the possibility is open, and I think Palestine needs to explore that possibility with Turkey or with other countries, and even with companies and oil and gas companies that could explore gas in the Palestinian exclusive economic zone.
Thank you. Unfortunately, we do not have time to take all of the questions. I'm going to read the first few questions from the chat, and then Professor or any of the speakers, you may comment on those, and then we will wrap up. But we will go a couple minutes over because we started a couple minutes late. So I'm just going to read the first 3 questions. My apologies to everyone else whose questions we are not able to get to. So first, we have a question of what efforts have nations made to develop the law of the sea? The next question is to Professor Qafisheh. I would like to have your comment on maritime delimitation disputes with Egypt, a state with adjacent coast to the Gaza Strip. Indeed, although Egypt recognizes the state of Palestine and its right to maritime zones in accordance with the UNCLOS, it has challenged the delimitation of these maritime zones on the basis of a problem of overlapping zones. In particular, Egypt disputes that the Palestinian declaration of its maritime boundaries would contravene Egypt's sovereignty over its territorial waters and would be prejudicial to Egypt's sovereign rights over its EEZ and continental shelf in the Mediterranean. Could you provide the Palestinian point of view on this claim? And then the third question we will take is companies that explore for minerals or oil in the borders of the Gaza Sea. How can Palestine benefit from these companies? And does Israel seize the revenues from the companies? And what is the legal ruling over these seizures? And unfortunately, those are all the questions we have time to take. If the speakers would like to comment on those questions, that would be great. Thank you.
Regarding the first question, I would like to ask Hanifeh probably if you would like to mention something relating to the Egypt-Palestine borders and what would be the possibility for delimiting these borders. اشرت لها يا حنيفه في العروض تبعتك، اذا بدك بس تقص شوي صغيره على موضوع
presentation, if you can discuss the borders between Egypt and Palestine and the challenges, especially that Egypt believes that some points that was pointed in the chart of Palestine overlaps with Egypt. Hanifeh, if you can comment on this. Okay, I will answer briefly. Palestine has been trying to friendly negotiating with Egypt since 2016, but Egypt is not accepting even to negotiate. I believe personally that Egypt is waiting for the destination that the agreements will move towards with Israel, between Israel and Palestine. My point of view is if Egypt and Palestine does not get an agreement, a friendly agreement, they have either arbitration or a mutual agreement. Nowadays, Egypt is not accepting negotiations. Palestine, I don't know how much time they will wait Egypt to negotiate. Still, Egypt is now up until now opting for negotiation and not agreement.
accession to the International Maritime Organization might provide an opportunity for Palestine to develop several or various possibilities regarding its maritime, I would say, affairs, including the question of preservation of marine environment, question of trade, the question of establishing a harbor and port in Gaza. And of course, we know that Israel is would deny these measures that Palestine might take. But I think the Palestine membership in the International Maritime Organization, Samah, maybe you can comment on this, would open some doors for Palestine, at least to put some pressure on Israel and maybe to other states who support Israeli supporters in that organization, particularly the United States and the United Kingdom, in this on this side. Samah, if you want to add anything on that, the possibility for Palestine, إذا ممكن تعمل تعليق سريع على.
Do you have a comment on this, on the possibilities or what can Palestine achieve through a membership in the International Maritime Organization, including agreements and economic benefits, fishery, shipping, travel, and all other gains? Samah? Yes, Doctor, I have clarified that based on the Constitution or on the treaty that established this agreement, it's a consultancy, so they suggest policies, but they don't force policies. Countries are obliged to implement such policies. If Palestine has a membership in this organization, this will enable or open doors to Palestine to develop the economy and develop the commercial transactions through maritime means. But still, a minute, sorry. Yes, fine. The most important thing is that they can also gain diplomatic benefits, more recognition of Palestine, also existence of the organization in London. This would encourage the Palestinian leadership, because the UK stance towards Palestine will change, especially that the UK is the headquarters of this organization, and this will be a political achievement. Still, the problem, as I said, is that the Palestinian leadership has other priorities. They don't want to get into this zone, especially that we see crimes against humanity. The Palestinian leadership is focusing nowadays on such crimes. It's true that they are interested in developing the economy, but they will find a solution for this after delimiting the boundaries. And this still takes a more priority. Maybe Muhammad, you can comment on this, especially that Palestine is already a member in the International Seabed Authority. This maybe allow for Palestine to benefit. Unfortunately, Doctor, the International Seabed Authority is giving a condition that they have the right to the treaty of the UN clause. The UN clause gives the right to all states, whether coastal states or uncoastal states, to exploit the resources in the high seas, but they provide a condition that the companies to exploit should have enough technologies to exploit the resources. So Palestine can ask other companies that are parts in the International Seabed Authority to exploit the resources, and this will be a financial benefit to Palestine.
In progress, but I think there are tremendous opportunities that are there over the sea, and I think the Palestinian government and the Palestinian researchers and the researchers in the world in general, like including our Italian partners and academic in the East Mediterranean Sea, I think are called upon to work much more on this area and explore scientifically, legally, economically, technologically, the various issues that can be raised and discovered. And I think it's not. I would just disagree a little bit with Samah. I think the other issues, the Israeli crimes that are going on daily basis, including today's crime in Jenin and Ramallah, and the killing of over 250 Palestinians even only this year, and the majority of them are civilians, should not in my view, should not overshadow or prevent Palestinians from looking for other opportunities available under other areas of international law, including the issue of the law of the sea. I think the issue has been ignored for long, and I think it's time now. It's the time for the Palestinians to take off the sea and explore the many opportunities that would be available there. And I would just conclude by answering the question regarding the work of Palestine with the international corporations and the companies, and that would have, I think, two sides. The first, the companies that would explore and exploit Palestinian resources, including fishing and scientific research, trade, and gas exploration and exploitation in relation with Israel and with other neighboring countries. And if these companies would use and abuse the Palestinian maritime zones, I think they should be responsible, not only as companies, but also their countries or the countries of nationality or registration, where these companies or ships are registered, and the oil rigs as well, which belong normally to international companies. These companies should know, and I think Palestine was clear on that. Just this year, or last year actually, the Minister of Foreign Affairs on the 12th of April 2021 issued a warning to all international companies and countries not to look or make any search or research or exploration or exploitation in the Palestinian maritime time zones. And it seems to me that the Palestinian government has an information that some companies and some countries, don't want to mention any country now just to avoid any political sensitivity, are using and abusing the Palestinian maritime zones. So if the companies undertake, and there was a question. There was a question regarding the ICC, the International Criminal Court. The companies might be responsible under international criminal law of the crime of pillage, or which is like stealing and taking resources from the country without its consent. So if these companies explode and explore the gas possibilities in the Palestinian maritime zone, I think Palestine would have the power to use various judicial possibilities, including, so if, and I think now Palestine is in the process of declaring to accept the jurisdiction of the International Tribunal on the Law of the Sea and the ICJ jurisdiction in with regard to the issues of the law of the sea. So Palestine can file cases, lawsuits against these companies as well as their countries, in addition to the international criminal court. But still, on the other side, Palestine would have the possibility to contract other companies in order to search, explore, and exploit resources in the Mediterranean for the benefits of Palestine. But here also the question would remain also, would these companies would be courageous enough to operate in the Palestinian maritime zones without the Israeli consent? Because Israel in this case might use force against these companies. But if these companies are related to powerful countries, for example, Turkey, Russia, or maybe some certain European countries who would be maybe convinced that they can take some actions for the benefit of Palestine, I think Israel will be reluctant to take actions against these companies and might be forced in one way or another to come to the negotiation table and let these companies to explore and exploit Palestinian maritime zones without its consent. So
Thank you. Yeah, thank you.
Can I?
If you just a very brief comment, yes.
Yeah, Dr.
Doctor, there's decision 1003 issued by the General Assembly in the 62 about the sovereignty over natural resources. Israel cannot discuss this right that is related to the right of determination, and Palestine can use this decision. There's
fishing companies or fishing ships were operating in the Atlantic Ocean, and the decision of the European Court of Justice was clear that these companies would violate the right of self-determination if they don't, if they explore or fish in these territories which belong to other peoples. And in this case, the issue of Western Sahara or the Moroccan Sahara and the coast overlooking that region were come into force by the international or the European Court of Justice. So, and I think that the same principle could apply to the Palestinian maritime zones offshore Gaza.
Thank you all so much. I apologize that we don't have time for the rest of the questions. So thank you for joining us today for this enlightening discussion on maritime delimitation in the East Mediterranean, specifically between Israel and Palestine. We hope that you all can join us for the second session in this series on the boundaries between Israel and Lebanon, which will be on December 19th at this same time. I want to thank the speakers, the guests, partners, participants in the discussion, members of the Jurists for Palestine Forum watching via live broadcasting, and everyone else here today. I also want to give a special thanks to our interpreters, Noor Haki and Malek Dirianya. My apologies for my pronunciation. Thank you all for this wonderful discussion, and I look forward to seeing you all soon. Thank you.
And thank you, Rachel, for your excellent moderation.
Thank you.
Thank you.
Thank you all.
Bye.